Hello, ladies and gentlemen. My name is Andrew. I'm a solicitor at Tanlo Solicitors, and we are now in the live that we have started. I'll just wait for people to come in, and then we'll start. Just waiting for people to come in, and then I'll start on the program. Just waiting for a few more people. If we come to about 10 people, then I'll start. Just a moment. If you've got any questions, just put them in the chat, and then I'll be able to go through your questions, hopefully. So if you've got any questions, just put them in the chat, or you can put them on the WhatsApp number, which is showing on the screen. Okay, thank you for those who have tuned in. My name is Andrew Nyamayaro. I'm a solicitor at Tanlo Solicitors, and today I'm hosting a question and answer session for immigration questions. So the first question that I have is that how can I change my visa from a 10-year route to a 5-year route or indefinite leave to remain? So where someone has been granted a visa under the 10-year route, normally it's a discretionary leave to remain issued under family life or a private life or outside of immigration rules. Where someone has been granted that visa, and it could be that they may have been in the country for a long time, but having had a period of um, undocumented stay, or maybe there's been some circumstances that has happened. Under those circumstances, someone will be given 10-year route. If you are on the 10-year route and if you qualify, you may be able to switch from the 10-year route to the 5-year route. Say, for example, you got your 10-year route on the basis of having a partner or a spouse in the UK, but you have had a period of illegal stay in the UK. The moment that you are granted the 10-year route, you are eligible to reapply for under the spouse route, um, 5-year route. So you will have to prove the usual stuff that you are in a relationship with a British citizen, or in a relationship with someone who has got indefinite to live, or has got a legal status in the UK, which is under the 5-year route in his or her own right. So you can immediately apply, or even apply after a few months or years to switch. You might also then reapply for another qualifying route, which will be as a parent. So you can move from the 10-year route to the 5-year route as a spouse or as a parent. But what it means is that you are going to pay additional fees to the Home Office. You are going to pay an additional Home Office fee if there's still a period that is still outstanding on your visa, then the IHS that is still remaining will be refunded to you pro rata what has been used on the visa that you, or the period that you've spent on your visa. So yes, technically it is possible to move from the 10-year route to a 5-year route. There's a lot of considerations that you have to take into account. um, for example, how many years are left on the 10-year route? Are you going to benefit anything by going on the 5-year route, or it's just an academic exercise that you are doing? But as a matter of principle, you should be able to move from the 10-year route to the 5-year route. Okay. Another question: how long does it take for the Home Office to correct a name error on passport or a biometric card? So the issue of a passport, if there's an error on the passport, it's not so clear from the question whether it's a foreign passport that has been used as part of the visa application, or it's a British passport. If it is a British passport, then you need to contact the passport office, and they will be able to change the error in your passport. But again, you have to bear in mind that the passport office will use the details that they get from the Home Office. So if you had a name error that was on your biometric card initially, then they will just get that name from the Home Office. So it means that you have to correct your name from the Home Office first, and then you correct in the British passport. If the error is on the biometric card itself, under normal circumstances, you should be able to notice it within the 10 working days. And if you notice it within the 10 working days when they send you the biometric card, there is an email that is on the cover letter for the biometric card. You email to them and you return the biometric card, and that biometric card should then be corrected. If you notice the error outside of the 10 working days, it means that you might have to do a new application for a replacement biometric card. And we have had instances where we do an application for a replacement biometric card, and then they will give you a decision that it's not a replacement. You have to use another process. Eventually, I think the best process would then be to do a pre-action protocol, and then you have to do, um, if worst case scenario, a judicial review. So it depends at the stage of when the correction is being done. Within the 10 working days, it should not prove so difficult. Outside of the 10 working days, the Home Office is very difficult to deal with to correct an error on a biometric card. So for those that are just joining us, I've responded to two questions so far. The first question being, can I convert my visa from 10-year route to 5-year route? And the answer is yes. And the other question that I was responding is, how long does it take to you have an error corrected by the biometric. As you know, at the moment, the Home Office is experiencing a lot of delays, and those delays are normally caused because of the Ukraine issue and also because of previous delays that have been with the Home Office. It's very difficult to tell you how long that takes, but there are delays with the Home Office, as you would have heard on the news. Another burning question that is going on these days is for the 18-year-old children. As you realize, a lot of people have come to the United Kingdom to work under the skilled worker, carer, or support worker visa. And most people would have had their children, and they are still supporting their adult children who are 18 years or above, but are still, say, at university, unemployed, or at college. So they want to bring those children to the United Kingdom. And it is very difficult for you to be able to bring a child that is 18 years or above to the United Kingdom unless if there is exceptional and compassionate circumstances. And the Home Office is very strict in interpreting exceptional and compassionate circumstances. So if you just put financial information or that he doesn't have, the child does not have someone to stay with, the Home Office will not accept that. Exceptional and compassionate circumstances are situations whereby, for example, the child has got very serious medical problems, maybe very serious mental health problems, maybe they are disabled, um, or there is social issues that are so serious that the child or the person, rather, because they are over 18, cannot stay by themselves in the United Kingdom. So it is really a factual analysis that needs to be done. You might have to produce medical evidence. You have to produce um, social worker reports if necessary, letters from the pastors or the imam from any college or university that they are attending, and so forth. Another option is just really to try to get a certificate of sponsorship for the for the 18-year-old child themselves, so that they can come and work independently of their parents. Of course, that will be a lot of more costs on the family, because if they come as a dependent, the Home Office fee is give or take 300 to 400 pounds. But if they're going to come on their own, then it means they have to do a lot more, do the English test, the TB test, of course, and the rest of it, which comes with the maintenance, etc. So 18-year-old children are causing a lot of problems for parents because of the compassionate and exceptional circumstances that are required by the Home Office. If you are in such a situation where you've got an 18-year-old and you have made a visa application or want to make a visa application, then you can contact us or any competent lawyer that will be able to help you in that situation or circumstances. The next question is about bringing children to the UK when the other parent is remaining behind. So in those, we've been asked questions by clients that either they are single parents or they separated from their partner, or the partner is remaining in Zimbabwe, doesn't want to come to the UK, or is deceased, or their whereabouts cannot be known. So under those circumstances, the Home Office would want, so the Home Office requirements will be A, both parents are coming to the United Kingdom with the children, or B, if another parent is remaining, then the parent coming to the United Kingdom has got sole responsibility. Or C, there is exceptional or compassionate circumstances as to why the child should be allowed to enter the United Kingdom. What is sole responsibility? Sole responsibility goes beyond financial responsibility. It shows that you are the person who's got the ultimate decision making responsibility for that child. You are the one who decides which school the child goes to, which church they go to, which activities they go to, which doctor they stay with, where they're going to be and with who and so forth? Do you send the money, etc.? So it is very important before you submit this application for a child that you have covered yourself for sole responsibility, because 9 out of 10 times the Home Office will send you um, an email or will contact you to say, give us the evidence to show that it's got sole responsibility. And even when you've submitted an affidavit or a statement from the parent remaining, they might say, because you've been able to communicate with that parent, so it means that you don't have sole responsibility, that parent can still you have some responsibility over the child. So you need to show factual circumstances as to why that child cannot remain with the remaining parent. If it's a girl child, then can she remain with the dad, or if the father or the other parent has moved on with another new family, is it conceivable that the child can then go and stay with the step parents, with the father, and so forth? Or if the parents are the parent remaining is in living in the village and the child was living in the city center or in the city setting, or if the parent he has got disability and so on. So it's all of the things that needs to be considered to convince the Home Office. Again, another question that is coming up is about recourse to public funds. For those that are coming on the skilled worker visa, it says that you have got no recourse to public funds. And people then ask the question, what is public funds? Um, public funds, okay, questions on the phone. On public funds are defined in the immigration rules, and I'm going into the immigration rules where the public funds or defined. So public funds means housing under Part 6 or 7 of the Housing Act, and under Part 2 of the Housing Act, attendance allowance, severe disability allowance, careers allowance, disability living allowance under Part 3 of the Social Security Contribution and Benefits Act, income support, council tax benefit, housing benefit, social fund, income-based job seekers allowances, income-related allowance. So all these universal credit is also included, personal independence payment, council tax, and the payment under welfare fund, discretionary support, discretionary payment. So all these classified as public funds. And if your visa says that you have got no recourse to public funds, then you cannot apply for these funds or receive these funds. You have also to be in mind that there's child benefit and child tax credit. So you have to be in mind of that. If you are on a visa that qualifies for any of these ones, then or rather, let me rephrase myself. If you are on a visa that says no recourse to public funds, you might be able, depending on the visa that you have, to be able to apply to get a recourse to public funds. The Home Office has been found um, to be breaching the no recourse to public funds, because at the court on 5 occasions or more, you have said this policy is unlawful to put no recourse to public funds on certain visas, but the Home Office just ignores the courts. So if, for example, you're on the 10-year route and you're a single parent with children, you can then apply for the visa to be given a recourse to public funds, or where there is circumstances that will make you destitute or you're now destitute, then you might consider to apply for a visa to be given under recourse to public funds. So, recourse to public funds, be very careful, because you don't want to breach your Home Office conditions because you are now getting public funds. But where you think that you might be entitled for public funds, I would say consult your lawyer, consult your solicitor or legal representative, so that they can be able to check that for you, whether you qualify for public funds. Okay, so if you've got any questions, please put on the chat or send me on the WhatsApp. We've got 2 WhatsApp message phones that we've given you. you can send the questions on there. I'm just going to look through the chat to see if we have got any questions that have been put through. Thank you so much to the person who's thanking me on answering the question for children. So let's see if we've got any other questions. If you've got any questions, um, I've got 8 more minutes remaining. If I get more questions, otherwise we might come to an end of our session. Just checking for more questions. And no questions coming in. The other question that I would maybe want to comment on, which I was recently asked, is how long does it take for someone to become a British citizen if they've come on a skilled worker visa? If you have come on a skilled worker visa, you do your 5 years on the skilled worker visa. And then after your skilled worker visa, you then do 12 months on indefinite leave to remain. And then after 12 months on indefinite leave to remain, you become eligible to apply for naturalization as a British citizen. So as long as you are meeting the requirements, for example, if you are now on indefinite leave to remain, you need to have spent at least 9 months out of the 12 months in the United Kingdom, and you then apply. You need to do the English test, the Life in the UK test. If you've got a UK degree, you don't need to do the English test. Another question that is regularly asked is the English test for people who want to come on the skilled worker visa. If you've got a degree at institute outside the United Kingdom, you can send your degree qualification to ECCTIS if you do not want to do the English test, and then it can be checked and verified by ECCTIS, and they will then do a statement of confirmation, which you can then send to the Home Office as part of your English certification. Okay. Do you have any other questions? Okay. Thank you so much. We do not have any further questions. We will be holding the question and answer session on different topics of law. We're doing immigration today. We might do things like employment. There's a lot of questions on employment, family. We will do that as well. And any other questions that you might have, we will endeavor to respond to those questions. Please subscribe to our YouTube channel. We've got more than 97 videos on YouTube, which you can watch in your own leisure. Also, subscribe to our Facebook pages where we can be able to give you content. There's a lot of content that is there as well. I've got a question that has just popped in. This person has got a daughter was refused because the person made a mistake on address, and she thinks she wants to know if she can be helped. So it depends with what sort of mistake it is. Is it a mistake on the address in the United Kingdom or a mistake on the address back from where the person is coming from? This question is it came through Facebook. So if you made a mistake on the address, again, the Home Office would look whether this is a misrepresentation. Are you lying to the Home Office? Are you trying to deceive the Home Office? Or it's an innocent mistake? If you are trying to mislead the Home Office or lying, then the applicant will get a 10-year ban under the Home Office immigration rules. I think it's Part 9. So if it's just a mistake on the address and you are not banned, then you can either make representations to the Home Office. But in this case, the visa is already refused. So you need to make a new application. And I hope your daughter is still under the age of 18 years. So you can make a new application. And when you make a new application, if someone has been refused, it's also important to address the reasons why that person was refused in the initial application or previous applications. So you need to make an application, address all the things that were wrong and make sure that as you make the current application, everything is correct. Um, um, Another question that has come in is that the address that was used was the address of someone whom they'd separated with and who was staying with them. And people do get in circumstances whereby they have to temporarily locate their children with a relative or a previous partner because they've come to the UK as a temporary measure. So if it's a temporary measure, then you have to explain it in the application that the address has been used as a temporary on a temporary basis because there is need for the child to come to the United Kingdom. So I would say in such circumstances, be upfront with your facts, justify why you are doing it, make a statement from yourself or from another person that is involved. But it is important to then make a new application addressing any other issues that are outstanding in the application. You can still contact us. Our contact details are on the screen. If there's anything that is private that you'd want to discuss off the screen. Okay. So thank you so much. And this will bring us to the end of our presentation today. We will be presenting for the near future on every Tuesday at 6 p.m. We will be presenting on different topics. If you've got any questions that you want us to touch on, you can contact us and we will comment on those topics. Not only in immigration, there's a lot of things that are affecting people in the United Kingdom, particularly the new arrivals from abroad who have come here. It could be issues to do with the driving, the work conditions, the family issues, the immigration matters, issues to deal with social services or the council. So many things that are affecting people and where we can help. We are more than willing to help you. Thank you.